On this week's 51%, the Supreme Court has ruled to protect access to the key abortion pill Mifepristone for now, as a legal battle over its 23-year-old FDA approval makes its way through the courts. We speak with Columbia Law School's Katherine Franke about the Texas case that started it all and what lies ahead in America's struggle over abortion rights.
This is not the end of the process for those who are challenging Mifepristone. So, stay tuned. There's going to be a lot more of this.
I'm Jesse King. It's all up next on 51%.
I was standing around like one of those girls I had seen in a movie. The whole world was a movie back then. I had my sunglasses on, I wanted to be seen without seeing shy Lolita. I wasn't really in it, I didn't really get it.
You're listening to 51%, a WAMC production dedicated to women's issues and experiences. Thanks for joining us. I'm Jesse King. Last week, we dove into the web of lawsuits surrounding the key abortion pill Mifepristone. Mifepristone is one of two pills commonly used in medication abortions, which make up a majority of the abortions in the U.S. Earlier this month, a preliminary ruling by U.S. District Judge Matthew Kacsmaryk of Texas would have suspended the Food and Drug Administration's 23-year-old approval of the drug, effectively taking it off the market nationwide. The U.S. Court of Appeals for the Fifth Circuit moved to preserve partial access to the pill as the case makes its way through the courts, but it would nix any additions to the FDA's approval starting in 2016, including the approval for the generic version of the drug and the ability to deliver it by mail. The Justice Department asked the Supreme Court to weigh in on how things should proceed, and at the time of last week's episode, we did not yet have that decision from the Supreme Court. Now, we do. So we're going to pick up where we left off with Columbia Law School's Katherine Franke. Franke is the school's James L. Dorr Professor of Law and the director of its Center for Gender and Sexuality Law. She says, for now, access to the drug is unchanged.
Mifepristone for now remains as available in every state in the country as it was before the lower court ruled. The issue is now going back to the Fifth Circuit, which is the appellate court that oversees the Texas District Court that had ruled in this case. And they will fully brief this issue. All the sides will. There will be, I'm sure, many, many amicus briefs filed by different interest groups. And the Fifth Circuit will hear the issue fully. And at that point, once they rule, the case will be back before the Supreme Court. But in the meantime, Mifepristone is available across the country just as it was before.
Okay, so that's where we are now. Just for those who may have missed last week's episode, let's review kind of how this started. What exactly is the argument being made in the Texas case for why Mifepristone's FDA approval should be suspended or revoked?
Well, they're arguing that the FDA's approval process was flawed. And even if it weren't flawed, that there is an existing federal law, a law that was passed in 1873, the Comstock law, that prohibits the mailing or the using of the mails to ship any drug or substance or instrument or anything that relates to abortion. And that law is still on the books. It's, by pretty much everyone's views until recently, was understood as a dormant law, or a law that had been overruled implicitly by both lower courts and the Supreme Court. But Dobbs put that back into question. And so what Judge Kacsmaryk did in the lower court in Texas is say that actually it's illegal to use the mails, and that could be the U.S. Postal Service, FedEx, UPS, any of them, to mail any item that's used in an abortion. And that was a pretty shocking ruling from him, to resurrect in the 21st century a law that had been enacted in the 19th century and had been pretty much put to bed in the 20th century as being unconstitutional. It's now been risen from the grave, if you will, to render the movement of any abortion-related medical supplies or drugs a crime in this country.
I'm actually really glad you brought up the Comstock Act, because that's an angle of the ruling we didn't really get to last week. Could you just tell us a little bit more about that? Like, just how far-reaching is the Comstock Act, and why is it suddenly in the conversation again? Why are anti-abortion rights groups pointing to it now, rather than like any time over the past several decades?
Well, let me start with the second question. Why they're using it as a tactic is because they can. The law is still on the books. It was never repealed. parts of it had been interpreted as being unconstitutional, as in conflict with Roe or some of the contraception cases. But to the extent that those precedent or have either been overruled or in question, it's an open question whether the Comstock Act is now a valid law in many respects. But just so you know what we're talking about, this is a law that was passed in 1873 by a kind of evangelical sexual prude, if I can say, who was very worried about threats to women's morality with pornography, sort of loose sexuality, abortion, contraception, and that sort of thing. So he was Mr. Comstock was on a morality campaign, and he convinced the Congress to pass this act in his name. And what it says is every obscene, lewd, lascivious, indecent, filthy, or vile article, matter, thing, device, or substance cannot be shipped through the mails. And then it has a second and third section to it that also prohibits the shipping of anything designed, adapted, or intended for producing an abortion, or is indecent or immoral in its use, cannot be shipped through the mails. So, I mean, if you think about it, it certainly would include Mifepristone, but also gauze or any kind of bedding that would be on a table where an abortion might take place. It's really impossible to imagine any surgical abortion taking place with instruments that did not come through the mail. We use the mail for shipping everything from the instruments that are used in a medical procedure to the Band-Aids or anesthesia or the gloves that the medical professionals use. So this is written so broadly that it would apply to every aspect of an abortion. And this is why the opponents of abortion have seized on the Comstock Law, because it would render abortions illegal, whether they're medication abortions or surgical abortions, everywhere in the United States.
Yeah, because it's a federal law, not a state law.
Exactly.
This might be a silly question, but is it normal for a law like this to be allowed to just sit there for 150 years instead of be repealed?
Well, this is pretty common, that when a court finds that some old-fashioned law is unconstitutional, it's very unusual then for Congress or the state legislature to go back and repeal that law. In a way, it's sort of a waste of their time, because if the law is not enforceable, why bother? And so there are lots and lots of laws that deal with the regulation of contraception or homosexuality or abortion, or even talking about sex and sexuality, that we would understand by today's standards are unconstitutional, and those laws were never repealed. But what's worrisome is that by overruling Roe versus Wade and implying, as Justice Thomas did in Dobbs, that they're prepared to overrule some other fundamental precedent that relates to sex and sexuality, some of these old laws will spring back into life. And we've seen that across the country, of these old laws being enforced anew, or being interpreted by state attorney generals or governors as being automatically good law, with Dobbs having been decided by the court.
So the Supreme Court is protecting Mifepristone access for now, while this case and others make their way through the system and the appeals process. It's likely that it will end up on the Supreme Court's doorstep eventually, though. Do you think Friday's decision gives us any hint of how the Supreme Court would handle this case officially?
No, we have no idea. When the court declines to take a case, as they did through their shadow docket in this case, we don't get a count of how many justices agreed with sending the case back to the Fifth Circuit for a full appeal, or not continuing the stay or the injunction in this case. We just know that there were two who dissented from whatever the others were, who voted in favor of sending it back to the Fifth Circuit. And that's Justice Thomas and Justice Alito, pretty dependable members of the court in opposing really anything that has to do with abortion. But what's pretty shocking about what Justice Alito did in his dissent, his written dissent, was to basically claim that there was no injury to the producers of these drugs, because in his view, the Justice Department, the FDA, and the federal government were not going to follow the law, even if ordered to do so by the Supreme Court. So for Justice Alito to anticipate in advance that the Biden administration was prepared to blatantly violate a federal court order is shocking. I just want to underscore how shocking that is. There is no precedent for that, for a president to say, Supreme Court has issued a valid order, I don't agree with it, and I'm not going to follow it. And particularly given Merrick Garland as the Attorney General, he is a quite conservative person, and I mean that with a small c, not an ideologically conservative one, but he believes in the rule of law. He believes in the separation of the Justice Department from the political wings of the administration, something that the Trump administration blurred time and again. And Attorney General Garland has seen as his primary mission the project of restoring the authority and legitimacy of the Justice Department, and doing so in a way that depoliticizes their work and sees them as following the rule of law. So it's as a practical matter, really unthinkable that the Attorney General would have advised the FDA or the Biden administration to not follow a valid federal court order. But that's what Justice Alito ruled, is it was likely that they would ignore the law and do what they were politically committed to. And I have to say that Justice Alito saying that follows what we saw from Judge Kaczmarek, is that these federal court judges are acting in extra legal ways. They're applying political, personal, religious, emotional arguments and reasoning rather than legal reasoning in their opinions.
I was going to ask about the polarized perception of the court between the Dobbs decision and the accusations of corruption against Justice Thomas now. I mean, when I spoke to Carmel Shahar last week, she mentioned, that the Supreme Court acted like it was washing its hands of abortion as an issue with Dobbs last year, that it was the state's problem now. But that's clearly not the case. Do you think the court cares how these kinds of cases impact the court itself, of how people view it and its integrity?
Some of them do, some of them don't. Justice Alito, I don't think, cares. Justice Thomas doesn't really care, but Chief Justice Roberts cares deeply. And that is his job, to care deeply about the integrity of the court. He's been trying very hard to hold a middle in this polarized court and to keep the court's reputation somewhat unsullied in this process. And he's failed largely. The more radical right-wing judges on the court have really seized control of the court's agenda and the kind of tenor of the court. And you can actually see it on Chief Justice Roberts's face in many of these oral arguments and his public appearances that is wearing on him, that he's not been able to reel in the likes of Justice Gorsuch in some cases, Justice Alito, certainly in these abortion cases, who are acting quite injudiciously and quite transparently politically. That's just going to have long-term consequences for the Supreme Court, but also for the lower federal courts, because they're just seen as yet another political branch whose rulings people have the option not to obey if they don't agree with them. And that is just a horrible, horrible future for our democracy.
We're speaking with Columbia Law School's Katherine Franke about the legal battle over the FDA's 23-year approval of Mifepristone. Mifepristone is one of two pills used in medication abortions. The second, misoprostol, can be taken by itself, although it isn't always as effective and can come with additional complications. Do you see misoprostol coming under a similar attack too?
Oh, I would expect that the opponents of abortion are prepared to challenge every aspect of the medication abortions and of surgical abortions. The Comstock Act would go after and criminalize all forms of abortion and terminations of pregnancies. And the advocates they're creative, they're well-funded, and they're unrelenting in the kinds of lawsuits and other maneuvers that they're pursuing to make it as difficult as possible for a pregnant person to terminate a pregnancy for whatever reason.
I guess, how do you see the larger abortion debate evolving? We've talked a lot about the efforts being made by anti-abortion rights groups, but is the strategy changing among advocates of abortion too?
Well, the courts are a reflection in many respects of what's going on in the country. This litigation is going on before judges that they're handpicking to hear these cases. It's no accident that Judge Kaczmarek heard this case, and the lawsuit was filed in his district so that he would get it. So that's the strategy of the opponents of abortion, is to pursue litigation before judges who are very friendly to the arguments they're making, and then to also have an aggressive legislative agenda in states where they have supermajorities in their legislatures opposing abortion rights, and governors that are more than happy to sign the legislation those bodies pass. But at the same time, the proponents of protecting reproductive rights and the full range of reproductive health care for pregnant people have plenty of moves that they're making in states where they have legislatures that are friendly towards abortion rights and want to defend them, and governors who want to do so. And then there's also litigation going on to defend those rights that we still have. And I think there's also a longer term game of what it would mean to re-secure abortion rights in the Constitution in a different way than we did in Roe. And that was actually my final exam question in my gender justice class last year, is if we think 20 years down the road, what might be a new way that the Supreme Court could recognize, a different Supreme Court than the one we have now, but the Supreme Court could recognize the principles of reproductive justice, not by replacing Roe with the same kind of ruling around a right to privacy, but perhaps as a matter of equality, bodily autonomy, personal liberty, or just a right to health care. There are all sorts of other levers that we could be pulling as a constitutional matter to secure reproductive rights and reproductive justice. And Roe itself was a rather meager win and a difficult principle to defend, given that it delivered so little. And so the repeal or the overruling of Roe in the Dobbs case was both a horrible defeat, but it's also an opportunity.
Well, Katherine, thanks so much for taking the time to speak with me. Is there anything I'm missing that you'd like our listeners to know?
Well, I think some people are seeing this Mifepristone case as the opening of a door to courts second guessing scientific and medical expertise, but that the government, we always look to the government for, whether it's the FDA or other agencies. But in many ways, this is really the middle of that process, not the beginning. There have been a series of cases before, the COVID cases, where courts second guessed public health judgments about mask wearing or problems with mass gatherings, vaccinations. There have been a couple of cases that have come from out of the Supreme Court second guessing health and worker safety standards or scientific evidence that the government has relied on related to climate change and the environment. And so this is just the next step of what is a larger, conservative, well-funded campaign to undermine the regulatory project of the government, to get out from underneath government regulation, from worker safety to health provisions of other kinds to abortion in this particular case. And I think going down the road, we'll also see similar attacks against the guarantee of gender-affirming health care, PrEP, requirement of HIV-related drugs in employer health plans, contraception, et cetera. So this is not the end of the process for those who are challenging Mifepristone and abortion-related drugs and procedures. This is just the middle of that project. So stay tuned. There's going to be a lot more of this.
Katherine Franke is the director of the Center for Gender and Sexuality Law at Columbia Law School. Katherine, thanks again.
Take care.
It was around this time last year when a draft of the Supreme Court's ruling in Dobbs versus Jackson Women's Health Organization was leaked in Politico, signaling to all that Roe v. Wade was all but officially overturned. As the nation approaches its first anniversary of Dobbs, a new coalition of 22 state lieutenant governors has formed to respond to it. The Reproductive Freedom Coalition says it will work to protect and expand reproductive rights and access to care. The group, which includes lieutenant governors from New York, Massachusetts, Vermont, and more, was put together by Connecticut Lieutenant Governor Susan Bysiewicz, a second-term Democrat. WAMC's Ian Pickus recently spoke with Bysiewicz to learn more.
I think there is a huge need for state leaders to band together at a time when women's reproductive freedoms are under attack, not just in state legislatures, but also in courtrooms across our country. And I was inspired after seeing the governors, my governor, Governor Ned Lamont, and 19 others put together a reproductive freedom alliance, and I thought it was important for lieutenant governors to create their own coalition because, interestingly, while there are 12 female governors, we have 25 Democratic governors, 15 of them are women. We are a very diverse group, and I thought it was important for us to get together to pool our resources, look at opportunities to learn from each other's legislation, administrative policies to protect and to expand women's rights.
Many of the states in the coalition have already strengthened their reproductive freedom laws and rules, and some actually even did so before the Supreme Court ruling preemptively. So specifically, what's the goal in many of these, as you mentioned, so-called blue states?
Yes, and I just want to be very clear that I did ask leaders in red states to join us, and unfortunately we didn't have any takers, but I will say that some of the states have actually passed constitutional amendments to codify Roe versus Wade into state statutes. Our state was one of the states that actually passed a Reproductive Freedom Act before the Dobbs decision. Our legislation protects women that come to Connecticut from other states where abortion might be illegal, and they are protected when they receive that medical care, and that same legislation protects the health care givers that provide that important health care. So we wanted to make sure that we were ready. Other states have adopted similar measures. Interestingly, other states are acting to try to support manufacturers of drugs for contraception or abortion that might become illegal. So we wanted to share resources and best practices, but also to stand up for women. So if you look at this coalition of 21 states and one territory, Guam, you're going to see a very diverse group of leaders, men and women who have stood up, and they together represent more than 150 million people across the country, where state leaders, both in the governor's office and lieutenant governor's office, have said, we're going to do everything that we can in our power to protect women's reproductive rights.
Why lieutenant governors? What do they bring to the table that is different from what their states and the governors are already doing?
I would say that just as governors have said that they want to stand together to protect and expand women's health care access, and just as Democratic attorneys general across the country are fighting this fight in courtrooms and legislatures, we are a very diverse group that have been elected by people in our states, and we want to stand up. Many of us heard when we were on the campaign trail that this was a very critical issue. I think voters want to make sure that leaders in their state are doing everything they can, both in their legislature or through administrative policy, to protect and expand women's health care access at a time when other states and courts are trying to take away those basic rights.
Do you see a state in the coalition that, in your view, has gotten it right in reaction to the Supreme Court ruling?
You know, I think many of the states that are part of our effort have done some really great things. Connecticut, for example, I think has always been a leader in this effort. Griswold versus Connecticut, a Supreme Court case in 1965, was the basis for the Roe versus Wade ruling. Our state codified Roe versus Wade into our state statutes in 1990. So we took steps very early, and we have continued to lead the way as we try to protect women, not just women in our own states, but women who may be coming to Connecticut to receive care that is illegal in their states. Let's not forget that more than a third of our states have acted to, in effect, ban abortion. And we've already seen in our Planned Parenthood clinics in Connecticut people coming from other states in order to get care.
What do you make of the current state of play on this particular issue? It is really fascinating to look at the map of the U.S. right now and see the patchwork of different laws and, territories where, you don't have access to X, Y, or Z, but states like Connecticut really haven't changed since the ruling.
I will say that if you ask voters what they want, they will stand up and say 2/3 of the voters in my state and across the country want women to have safe access to abortion care and to women's reproductive health care. Look at the Kansas referendum, the vote that they had. It was so clear. It won by 20 points. And so it's amazing to me that there are state leaders and courts for the first time in our country's history that are trying to take away long-established rights, rights that have been in place since the early 1970s, away from women. And it's not just on the reproductive rights front. We also see this in other Supreme Court cases, like a recent one that put the right to gun ownership over the safety of women. So we are seeing rights being taken away. This is an extremely disturbing trend, and I can't think of a more basic right that women have than to determine and to have autonomy over their own body, because if you don't have bodily autonomy, how can you ensure your own economic security?
Connecticut Lieutenant Governor Susan Bysiewicz, a second-term Democrat. Thank you for taking the time to speak with us. We really appreciate it.
Thank you so much for having me.
You've been listening to 51%. 51% is a national production of WAMC Northeast Public Radio in Albany, New York. It's produced and hosted by me, Jesse King, with help from our associate producer, Jody Cowan. Our executive producer is Dr. Alan Chartock, and our theme is Lolita by the Albany-based artist Girl Blue. Just a reminder that you can listen to 51% anytime at WAMCpodcast.org or wherever you get your podcasts. On social media, we're at WAMC Radio, and you can stay in the loop by signing up for our weekly newsletter, Airwaves, at WAMC.org. We hope you'll join us next week. Until then, I'm Jesse King for 51%.
I was every single girl, I was nobody else, I was so sure of myself. I was 15 and a half. He was a hollow laugh, and I lost my cool somewhere along the way. At night and down the hallway, I had to learn how to look away. I lost my cool.